Hello, everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. As always, I hope you'll enjoy this legal education content, and today will be the day I earn your subscription. For today's story, we're doing a very brief one, actually, just about Osha mandates. Surprising absolutely no one, Osha, of course, is not taking their defeat at the U.S. Supreme Court merely on the chin. They are looking for ways to circumvent the U.S. Supreme Court, which kind of makes sense because the original regulations were written to circumvent certain processes, namely the standard processes under the Administrative and Procedures Act. In fact, if you hear various quotes from the Biden administration prior to the adoption of the old Osha mandates, you will hear them say things like that these were designed to get around Congress, or these were designed to get around various limitations. So they're looking for a mechanism to impose their policy other than by, creating new law. Let's find some mechanism in law that currently exists, however tenuous, that we can get through our current preferences. And from the OSHA organization that bypassed the entire Administrative Procedures Act in the first place to put in these emergency orders, this is, of course, not surprising that OSHA would look for some new mechanism. Not surprising at all. So let's see what they've got, and let's see what, this article has to teach us about what OSHA is trying to do. So this is from EHS Today, and this article is entitled OSHA to Try Again. Despite the U.S. Supreme Court's recent ruling, OSHA plans to press on with vaccine mandate regulations. I mean, if they can find any way or any argument, right, they're going to try. Even though they were just shot down by the Supreme Court, they're going to try because, they must have their policy preferences in place. The article goes on to say, late last year, OSHA issued an emergency temporary standard, which by its own terms bypasses the normal rule and comment making process of the Administrative Procedures Act. This is just a thing that they can just issue that goes into effect essentially immediately because it's an emergency and there's not time for the normal process of the Administrative Procedures Act. So they've already tried to circumvent not only their own authority, they've also tried to circumvent the authority of how to promulgate rules under the Administrative Procedures Act, which basically says how every federal agency is to promulgate rules. That's what the Administrative Procedures Act does. You want a rule? Here's how to go about making rules. They didn't want that rule, though, so they tried to circumvent that entire thing. So the old rule, of course, required employers of 100 or more workers to ensure their workers received vaccine for COVID-19 or be tested for the disease on a regular basis. And of course, as they note, that emergency temporary standard was struck down by the United States Supreme Court. At the same time that OSHA issued that emergency temporary standard, it also chose to launch formalized rulemaking proceeding, which was aimed at eventually turning the ETS into a permanent regulation. So let's have our cake and eat it too. Let's do the ETS and also try to do this through the normal rulemaking process, which was aimed at eventually turning it into a permanent regulation. That proposed rulemaking got lost in the uproar sparked by the emergency temporary standard and the subsequent court challenges mounted against it, along with controversies that arose over the mounting number of other vaccination and mounting vaccine mandates, which at times seem to be changing on almost a daily basis. Yeah, that too. The masking requirements, vaccine requirements, health requirements, the various regulatory bodies have taken many, many different positions over the course of the COVID. And as we recently read in a recent editorial from The Atlantic, apparently, even to some people, it doesn't even matter if those policies are necessarily logical. When OSHA announced on January 25th that it had withdrawn the COVID-19 vaccine mandate in the wake of the Supreme Court defeat, now they did that for a very technical reason, because the entire thing that went to the U.S. Supreme Court was based on an injunction, right? The U.S. Supreme Court, when they heard the OSHA case, wasn't deciding the merits. They were deciding an injunction. Injunctions are decided on a different standard. They're never afforded as a matter of right. There's a 4-part standard we've discussed before for issuing of injunctions. So when the Supreme Court struck down the Osha mandate, they didn't, strictly speaking, strike down the Osha mandate. They didn't. What they did do was confirm the injunction against the Osha mandate, which is not quite the same thing, because it was a preliminary injunction. The U.S. Supreme Court didn't say ultimately the mandate was illegal. They didn't. They said that the injunction was improper. Now, you, of course, can try to infer, to some degree, merits from the injunction, or vice versa. But they are different issues, and sometimes they do come out differently. It's not necessarily one for one. So what the Supreme Court was asked to decide is an injunction. And they said the injunction can stand. So that meant when they were done with it, what they did was remand it. They remanded it back down to the lower courts. Because now the issue is, well, the injunction is dead, but the courts could still have a merits hearing. They could still actually go through a full trial, whatever that would look like, incidentally, in terms of this context. But they could go through a full formalized hearing / trial of some variety. And then ultimately that could come out with a merits decision. That merits decision, incidentally, could be, you know what, OSHA's right on the merits. Because again, the Supreme Court was deciding the injunction, not the merits. I'm not saying that's what the district court would do. I'm just saying that they could do that, maybe, depending on what the facts were. So the reason that OSHA had to withdraw the vaccine mandate is because the Supreme Court didn't, strictly speaking, kill the mandate. They ruled on an injunction. And so they were going to send it back down to lower courts for further proceedings. By withdrawing the mandate, they mooted the issue, because now there's no longer a live controversy, because the issue is over, because there's nothing to have merits over, because they withdrew the mandate. Now, the reason you do that is because if you're looking to do some sort of new regulation, you don't want to do that at the same time, preferably as the old regulation is still being banded around in the courts, because then maybe the court will start trying to deal with that issue, or it will sabotage your lawsuit or something. So this is fairly common, right? We're going to kill the old regulation, withdraw it to moot the issue. Now there's nothing for the lower courts to do on the merits. There is no merits determination on the OSHA mandate, never has been. And now maybe we can try to get there through some other process, through an improved mandate, perhaps. And maybe the courts will look on that, on the merits, more favorably. So that's why they did that on a technical matter. So when they withdrew that, it may have seemed to many the ruling had settled the vaccine issue, but the assumption couldn't have been more wrong. On January 26th, the agency reported that it would continue to press ahead with developing the permanent rule designed to accomplish the same goals as the ETS. It was forced to withdraw on the High Court's defeat, which again, they can do. I mean, at least they're not, whether or not they can do it successfully is a whole nother problem, but they don't have a Supreme Court precedent telling them they can't, because the Supreme Court was ruling on the injunction, not the merits. So if they want to take a shot, again, at the merits of the thing, they can do that. Incidentally, this happened somewhat notably to the Trump administration regarding immigration policy, where it took 3 tries. And I think the U.S. Supreme Court struck it down both twice. I know they did once. They might have done it twice with various immigration policies by the Trump administration. And the Supreme Court turned it down not once, but twice. But the third time, the Trump administration, after modifying the policies, was able to get it past the Supreme Court muster. So this is kind of at least similar to that in some respect, right? We're going to try to deal with what the court said and try to improve it, so we'll get past the court. So we'll try again under what authority you have. And Trump got it right the third time. So whether or not OSHA can ultimately get it right or not, or whether or not they ultimately have the power, has not yet been decided, just by way of legal education on all this. Marty Walsh, Secretary of Department of Labor, for which OSHA is part of, note not Department of Health, also gave an explicit warning to employers when they reacted to the Supreme Court, saying, quote, OSHA will do everything in its existing authority to hold business accountable for protecting workers, including under the COVID-19 National Emphasis Program and under OSHA General Duty Clause. So the OSHA General Duty Clause, as the name suggests, because OSHA is the Occupational Safety and Health Act, the General Duty Clause basically says, in short, employers have a general duty to their workers for health and safety in general. And then, of course, there is more specific stuff on top of that. But, there's a nice little kind of catch-all clause of the general duty. So we're going to try to do it under the General Duty Clause, which I think has already been addressed by the courts, but, whatever. In order to issue a general duty violation, OSHA must prove there's a recognized hazard that poses the risk of death or serious bodily harm, and a feasible means of protection exists, points out Chris Palmer, a partner with the law firm of Michael, Best, and Friedrich. The recognition and feasible means of protection are generally identified in industry consensus standards and other governing documents. So, again, in general, is there something employers could do, in general, through the use of PPE or filtration or otherwise, to keep their workers safe? Now, when it comes to OSHA and OSHA regulations, as long as what they're doing is only within the confines of the workplace, then, at least to my mind, they won't run into the same problems they did with the vaccine mandate. The fundamental problem with the vaccine mandate, in my view, was that the vaccine by its nature impacts you outside the workplace. Because it's not like you get the vaccine and then the vaccine gets withdrawn when you leave the workplace, as it would be for PPE, for example, or a hard hat. Wear this hard hat, wear this safety vest, wear these gloves, wear this PPE, wear this lifting belt, and so forth and so on. Those are all things that exist within the confines of the workplace. When you leave the workplace, you no longer have to wear the hard hat and the safety belt and the gloves and the lifting belt and any of that stuff, right? Because OSHA's authority does not extend outside the workplace. So if this was a major problem, in my view, with the OSHA mandates, is that they said, well, vaccine. It's like, well, first, there's a couple problems with it. First of all, is that it extends beyond the workplace. So that's the problem. That's a problem, major problem for me. Second problem is requiring a person to do something fundamentally to themselves medically, right? Again, it's not just wear this stuff. It's take this drug, take this vaccine, take this chemical. A little bit different. And also has some autonomy issues on top of it. And then, of course, also, as we discussed, OSHA, unlike state level authorities, doesn't have generalized police power, the generalized power to do stuff. So their authority is more limited in that respect too. So there were quite a few problems with the OSHA mandate of the vaccines. But to the extent that OSHA is going to require you to do things that only extend within the four corners of the workplace, they might be on more solid ground, legally speaking. So that's just, again, it might get into the specifics. I am not saying, please take note, I am not saying that anything OSHA wants to do within the four corners of the workplace is necessarily legal. I didn't say that. I simply said that was the fact it extended beyond the workplace was a major problem. That doesn't mean that if it were fully within the workplace, there aren't necessarily other problems. So I just want to make that point clear in case it gets lost. I am not saying that OSHA necessarily has the power to do anything they want when it comes to safety and health within the workplace. We'd have to do a different analysis. It's just that for me, because what they were doing was outside the workplace, that was kind of a deal breaker for me for OSHA. If the vaccine somehow was wholly within the workplace, that would change the analysis somewhat. Moving back to the article. In order to issue the general duty violation, OSHA must prove there's a recognized hazard that poses a risk of death or serious harm and a feasible means of protection. Points out Charles Palmer, a partner with the law firm of Michael Best and Frederick. The recognition and feasible means of protections are generally identified in industry consensus standards or other government documents. Quote, certainly guidance issued from the CDC and prevention could be identified as a source for employees' general duty. Perhaps, yes. But as we've all experienced, that guidance changes rapidly and contains so much detail, it's difficult to know exactly what part of the guidance will meet its duty. This is also a problem, right? And not normally a problem you have in OSHA world. You don't normally have a lot of problems when it comes to, for example, wearing hard hats. The policy, for example, wearing hard hats is fairly consistent in the workplace. It's not like some days some people have to wear hard hats and other days they don't. Sometimes we change the color of the hard hats. You know, that's not normally how it works. It's kind of like a binary thing, and it's a fairly stable binary thing, which makes it fairly easy, well, I guess in one sense, for employers. There's a lot of regulations, so it's not easy in that sense. But it is easy in the sense of it being predictable. So even though there's a lot of stuff, in a lot of senses, there's a lot of stuff, which is why you have OSHA compliance officers, because there's a lot of things. But they're consistent things. They're not where you have to look up what the rule is that day. So with CDC constantly changing its guidance, that would be a bit of a problem when it comes to an OSHA perspective, because, like, what are you supposed to do as an employer? Is a very reasonable question. I don't know. Another source is OSHA's own guidance, Palmer sends. The August 2021 guidance identified 11 elements to describe the role of employers in protecting workers. Okay, so here's some things OSHA wants you to do with respect to COVID. Okay. All right, let's see. Now, we'll just do this very superficially, right? We're doing this very superficially analysis. We are just going to do the back of the envelope. Does this seem like a thing that OSHA can do? I'm not saying they can do it. I'm saying it seems like I'm just doing a probability assessment, right? Does this seem like the kind of thing they probably can do? Does this seem like an OSHA kind of thing? That's the question I'm trying to ask myself at this exact second. Not necessarily whether or not they can, but does it seem plausible? All right, so here's 11 things that the OSHA wants you to do as an employer. Facilitate, but not necessarily require, employees getting vaccinated. Yeah, that seems plausible. Instruct any workers who are infected, unvaccinated workers who have been close to contact with someone who tested positive, and all workers with COVID-19 symptoms to stay home from work. Yes, that would be a good thing. Stay home from work as a necessary remedy, maybe, but if you're infected, if you've had close contact with somebody, if you have COVID-19 symptoms, don't come to work and spread that disease. That is something that impacts the inside of the workplace. Plausible. Implement physical distancing in all communal work areas for unvaccinated and otherwise at-risk workers. Now, this is again, we're trying to analyze this from a whole bunch of perspectives. Some of these requirements may make it difficult or even impossible for employers to necessarily comply. But then again, when it comes to safety, money isn't necessarily a concern because safety is the primary concern. In fact, we've seen lawsuits over that where OSHA I think we saw one from the Supreme Court one time where OSHA tried to explicitly take in cost to the employer, and it's not one of the things in the statute. That they can't take it into consideration. So, from a safety perspective, maybe they can regulate this. If it imposes too high a burden on the workplace, that may or may not influence the policy. But it's within the workplace, and so It seems like something that, would necessarily only impact the workplace, right? It's in communal work areas, so it's within the four corners of the workplace. So plausible. Provide workers with face coverings or surgical masks as appropriate inside the workplace. Provide them with PPE. Yeah. Educate and train workers on COVID-19 policies and procedures. Sure, why not? Inside the workplace. Safety training. Suggest or require that unvaccinated customers, visitors, or guests wear face coverings. Okay. I mean, again, it's inside the workplace. I don't know if you've ever been to a workplace that requires hard hats as a guest, but they make you put on a hard hat, or requires a hairnet, or requires safety goggles, or requires ear protection as a guest. And they'll make you wear that as a guest while you're there. So this is not, again, unheard of. So, within the workplace, yeah, maybe. Maintain ventilation systems. I mean, that's just generally good policy, I'm sure. Provide routine cleaning and disinfection. Record and report COVID-19 infection and deaths. Any sort of injury or death that occurs in the workplace is OSHA's domain. They kind of want to know about that kind of thing. Implement protection from retaliation and set up anonymous process for workers to voice concerns. Okay, fair enough. There's various statutes dealing with whistleblower protection for various kinds of things. Just because you're whistleblowing doesn't necessarily mean you have protection, because the whistleblower protections are tightly written and they're context specific. But, if they want to come up with some kind of whistleblower protection for people reporting OSHA violations, they might be able to do that. That might be a thing that's possible. And follow other applicable mandatory OSHA standards, including those governing PPE, respiratory protection, sanitation, employee access to medical and exposure records. So these kinds of things from their guidance kind of make sense. Again, not necessarily saying all of them are legal, nor am I saying that any of them in particular are illegal. I'm just providing a sort of back-of-the-envelope superficial analysis. We could get into the weeds, obviously, on more specific issues, but at least we're within the confines of the workplace. We're not asking people to modify something about themselves fundamentally. And these seem at least somewhat comparable to other regulations that are already in place that I've kind of talked about. So, all that stuff. Palmer notes that while the vaccine emergency temporary standard contained a business-sized threshold, the OSHA General Duty Clause applies to all employees, so the guidance is not limited to employers with 100 or more employees, which makes way more sense. Why would it be 100 employees or more? What other regulation is there in business that applies to a particular number of employees? It's like I've said before. It's not like if you have a construction company that has 99 workers, that you don't have to wear the hard hats or the visibility vests or the lift belts or whatever, right? It's like, what kind of thing is this? I'm an employer. I'm an employer in the construction trade. I have 99 employers. Boy, isn't it convenient that those hard hat protections and lift belt protections and visibility vest protections and so forth and so on, isn't it convenient it doesn't apply to me because my 99 workers are safe? But if I had that 100th worker, man, that would put me over the line. See, this doesn't make any sense. It makes absolutely zero sense. So, obviously, if you had a construction company with one employee, you would still need to take safety measures for the one employee. Because, they're in a job that has some risk to it, and you have to ameliorate that risk. So the fact that they want this to apply to all employers at least makes way more sense than the 100 or more bullshit they came up with last time. If you implemented a policy already, consider updating it to address these 11 elements and watch for new amounts from COVID in the coming weeks. Okay. All right, so let's talk about how a rule is made. One problem with the Department of Labor's strategy is that by pursuing the normally drawn-out step-by-step rulemaking process, OSHA will only directly address one of the Supreme Court's majority objections to ETS that had been abruptly declared by administrative fiat instead of being developed like other regulations as required by Congress, including allowing time for gathering of data to support it and providing opportunity for rulemaking. Yes, this is exactly true. The fact that they bypassed the APA was only one of the problems of the Supreme Court. And incidentally, from my reading of the case, was not their principal objection. They took note of the fact that they bypassed the APA. But at least in my humble opinion, that was not the primary basis for the Supreme Court doing what they did with the injunction. The primary basis for the Supreme Court doing what they did is because OSHA doesn't have the authority in its relevant law. There's a couple reasons for that, as the Supreme Court noted. I will go over some of these reasons just, by way of reviewing the law. Okay, here's a couple of the reasons, right? We discussed OSHA has the general power to do stuff. Okay. What are the problems? All right, here's a couple of the problems. Number one, the virus is not necessarily an occupational risk. It's a risk that exists in the broad, wide world. That was kind of the Supreme Court's major rationale, not necessarily the rationale I would have gone with. Again, the fact that it goes outside the workplace was more my primary rationale. But the one the Supreme Court actually went with is because they said it's not an occupational risk. It's a risk that exists outside in the broad, wide world. There's nothing about the business or the nature of the business that is producing the risk. Not sure I 100% agree with that rationale, but that was what the Supreme Court said. I think other rationales are better. So that was problem number one. Problem number two, health in terms of medicine or health in terms of disease is not really what OSHA does. That's more like the Department of Health and the CDC and stuff like that. Those are the agencies that have this kind of generalized issues with health when it comes to like medicine and that kind of thing. Is more CDC, Department of Health. This is Department of Labor, not Department of Health. So problem number two, this probably belongs to the CDC or the Department of Health. Problem number three, the major questions doctrine. The major questions doctrine is this idea that where Congress grants generalized authority, it does not include authority to do stuff that are major questions. What do I mean by that? Well, I can give you the example on point, which is what we're talking about, right? I've already told you, OSHA has the authority in the statute, generally, to take steps to make the workplace safe. They have this generalized authority. The authority in the General Duty Clause is not cabined like it was in the CDC when we were discussing the rent moratorium, right? The CDC had a whole bunch of list of things to do and then other stuff. And we discussed why it didn't make sense within the CDC. But the OSHA isn't written like that. OSHA is written much more broadly. It's written to have the general power to do stuff. Okay, so is that really the general power to do all the things? And the Supreme Court has previously said no, in this and other contexts. So when is the general power to do all the things not the power to do some of the things? And the answer is what they call major questions, right? Major questions. And what is that exactly? Well, there's not a really great definition, but it's basically when it's a really big deal. Basically the conceit by the Supreme Court and the other federal courts is that when an agency is doing something that's a really big deal, they can't just use generalized power to do the thing. If Congress really wanted them to have the power to do this big thing, they would have given it specifically, right? Because the problem, of course, is that if you read the general power to do stuff broadly, it would mean on its own literal terms, it would be unbelievably expansive. And we're going to assume Congress didn't mean it quite that expansively. So this idea of the major questions doctrine. And that was another problem with the Osha mandate. Because again, the nature of what they were trying to do, force people to take a vaccine, change something about themselves fundamentally in getting this vaccine put into their body. So one of the Supreme Court's rationales is, the general power to do stuff doesn't include this because this falls into this major questions doctrine. If Congress really wanted OSHA to have the power to mandate vaccines, probably would have spoken a little bit more clearly on that. Probably just would have said general power to do stuff, which includes, this. Too much. Okay, there's that. Then also on top of that, there's a delegation of legislative authority problem for similar reasons. So the major question doctrine and delegation of legislative authority are somewhat tied together. So they'll sound somewhat samey. They're slightly different, but they're kind of related. All right. Congress doesn't have the power to delegate legislative authority. Only Congress has legislative authority. So then you have to get into these questions about what is legislative authority? What exactly is that? So I'll give you an example where it's not legislative authority. Okay. Congress writes a law and it says the Department of the Interior shall decide the hours of operation for the lands under their control. Okay, that's the statute. The Department of the Interior shall decide the hours of operations, the days and hours of operations for the lands under its control. Okay, that's what it says. All right, great. Now, when the Department of the Interior then goes and promulgates rules on the days and times, that's not legislation, even though they're deciding it more specifically. And they can decide it differently for different places. Like, this parcel of land is open from 9 to 5. This parcel of land is open from 1 to 3. This parcel of land is only open at 4 p.m. on the second Sunday after the full moon. Or whatever, kind of makes sense, because again, they also have to be rational. But, whatever makes sense for those individual parcels of land. So even though they're creating more specific rules, that's not legislation. That's just being the executive. Congress said, go do this. And they're the ones that actually put that into place by the executing it. Okay, but what is legislative authority? Well, more like this, because again, Congress didn't say to OSHA in the general duty clause, go do the vaccines. They didn't say that. They said, you have the general power to do stuff. Now, the problem with the general power to do stuff is, again, if you read that very, very broadly, then suddenly you're in the position where it's so ungrounded, so undefined, that OSHA basically gets to write its own ticket, right? If you have the general power to do stuff, what is that? If you're the one who gets to determine what that is, then basically at this point, the idea is that you're writing your own legislation, because now you get to determine what is and is not within your domain. Right? When we said hours of operation, that was limited. When we said the general power to do stuff, kind of unlimited. So one of the other problems, and one of the reasons the major question doctrine exists, is because of this. It's because, hey, wait a second. If we read this literally on its own terms, Congress can't do that. Congress can't delegate the authority to OSHA to, hey, go do whatever the hell you want to promote the health and safety of the workplaces. Too much. That's legislative authority. Can't do that. So that is part of the problem as well. So there were just some of the problems that existed from the previous OSHA mandate. Delegation of legislative authority. Major question doctrine. Delegation to other agencies. And of course, the Administrative Procedures Act problems on top of other things. It was a long list. Okay. All federal agencies are directed to take certain specific steps outlined in the Administrative Procedures Act when creating a rule. APA requirements include allowing time for the public to review and comment at each stage of the process. Over the years, Congress has added other requirements, including obligations for agencies to perform environmental and small business impact studies. A proposed rule can only become a final rule the agency is allowed to enforce after all these steps are completed. Once the final rule is announced, it can then be challenged in court by people who think they'll be negatively impacted by it. In cases where the rules are relatively benign and non-controversial, this whole process can take 6 months. Yeah, I mean, if it's a fairly simple thing, then yeah, no problem. However, when the rule generates intense controversy and the courts become involved, the entire process can take years. For instance, the most recent changes that were made to the Department of Transportation's commercial truck and bus drivers' hours of service regulations ended up taking 15 years to complete. That is a long time. Although OSHA's proposed vaccine regulation would address its failure to follow the APA, so yes, it would moot that issue, it fails to address other concerns about the agency's authority to address non-work-related illnesses. Because again, that was the Supreme Court's primary rationale. In their view, was that the problem fundamentally was that the nature of the hazard was not an occupational hazard. The nature of the work did not arise from the workplace, in the Supreme Court's view. The justices point out that by the agency's enabling legislation, the 1970s Osha Act specifically limits OSHA to addressing injuries and illnesses that occur to employees at work, but not those affecting the public in general, such as the flu and off-the-job automobile accidents, for example. Well, I'm not 100% sure about that flu thing, to be honest. Off-the-job automobile accidents, yes. On-the-job automobile accidents, though, no. OSHA does apply to on-the-job automobile accidents. So I'm not so sure about that. But then again, that's what they seem to say. So that's my opinion versus the Supreme Court's opinion. In fact, the DOL's insistence that OSHA pursue this rulemaking proceeding is reminiscent of Biden administration's defiance of law. Last year, the Supreme Court ruled the CDC lacked authority to halt nationwide apartments and house evictions. Yeah, this one is worse, though. This one is worse, in my humble opinion. The reason it's worse is because the CDC thing made zero sense from the statute. If we can all remember in our heads that far back, when the CDC was doing this with the rent moratorium, they were using a statute that says, and I'm going to paraphrase here, the CDC has the authority to clean stuff, disinfect stuff, destroy infected stuff, prevent the importation of infected stuff, sanitize, clean, destroy property that's infected, and other things. And as I pointed out, a rent moratorium is nothing like any of those things. It's nothing even close to any of those things. So when, the Supreme Court did what it did and allowed the moratorium to naturally expire in like 3 weeks, and then the Biden administration came on and extended it anyway, and then the Supreme Court had to whack them down, I thought that was unbelievably disrespectful of the Supreme Court. And because the authority never made any sense. At least here, because they kind of got a merits decision, right? They got a kind of merits decision, and then on remedies, the Supreme Court said, we'll let it expire naturally, which is a valid remedy. I know a lot of people are upset about that, but we talked about this in terms of remedies before. Like, what do you do about it? And so letting it expire in 3 weeks was a reasonable remedy. I know some people on the right disagree with that, but it was a reasonable remedy, if not perhaps the one people preferred. But then they defied all that and did it anyway in the clear defiance of the statute. Here, at least, they have this general duty clause. So it's not quite as egregious as the CDC, because at least the OSHA does have this clause that says they have the general power to do stuff. So at least them saying, hey, the general power to do stuff includes vaccines is not quite as stupid as when the CDC said, hey, the power to sanitize and clean things includes the ability to put in place a rent moratorium. You see the difference between those two things? You see why I think the one is more egregious than the other? See why one is stupider than the other? At least in my opinion. Yeah. So then the administration ordered the CDC to issue the same order differently, only have it swiftly stuck drown. Yeah, that was bad. Meanwhile, time is growing short for other governmental testing mandates. A federal appellate court handed down a decision after the Supreme Court rejection of OSHA's emergency standard, also struck down a separate Biden administration decree ordering all federal employees must submit to the jab. I don't believe that's true. I think it was federal contractors, not federal employees. I don't remember a federal court striking down the order relating to federal employees. I think this article is wrong. If there was a decision with respect to federal employees, it has missed my attention. The article continues. The unpopularity of government-imposed initiatives undertaken to combat coronavirus recently manifested itself in Canada, where the trucker protests over vaccine requirements in that country and at the border with the United States. Meanwhile, parents across the United States have grown more vocal in their objection to the masking of students in schools, and some states are moving to remove some of the lockdown orders that have been in place, which as functions of state-level authority are in a completely different place than federal level authority. We've talked about this, about federalism, right? So these state mandates, even if they're dumb, raise much different questions than it does with the OSHA mandates because of federalism. The article concludes, people are losing their patience with these restrictions and become less reticent about expressing their opinions. Elected officials are aware of this and making their decisions with one eye at the elections. I would think so, because that's one of the way that people fight back is through the election process. So all that stuff. So yeah, OSHA's going to try to promulgate this through formalized rulemaking, but I don't see how they're going to do what they want to do with the current statutes in place. Because the Supreme Court, although it certainly noted the fact that they circumvented the APA, that did not seem to be the linchpin of the Supreme Court argument. So it seems like a waste of time because I don't see how OSHA is going to be able to get to where it wants to be under the current statutes for all the reasons we talked about, right? I already listed all those reasons explicitly. So we don't need to go through that in detail again. But, it's not surprising that they're going to try. Let's take a look at some of your comments that you've made along the way, or your super chats that you've made along the way. Vaccine mandate for federal workers blocked by second court. Thank you, Stephanie. I'll do some super chats, and then I think we'll check this article. Interesting. Very interesting. There was only one super chat today. Rogue Accountant gave $50 before the start of the stream. Thank you very, very much, Rogue Accountant, to say, I know I'm early, but hell no, OSHA. Yeah, I agree with you on that as well. Thank you very much for your generous super chat, Rogue Accountant. All right, so now I'm going to take a quick look at this thing from Stephanie. Yeah, I agree with you as well. Stephanie knows her shit. For those of you who don't know, she is a corporate director of safety. She runs the entire corporation's safety programs. She's the head, so she knows a little bit about some of the subjects we're talking about. She knows a little bit about some of the stuff we're talking about. Man. All right, let's take a look at this. See what this is. This is from February the 10th. This just happened. February the 10th. This just happened. Well, comparatively. Super Iron Bob gives $10. Say, just got here, but have a second one. Well, thank you very much for that generous super chat. It is appreciated. Let's take a quick look at this thing, because, I missed a memo on this. It's a little bit late in the day, by the way, incidentally, because the mandate for federal workers was long ago, but I guess someone was fighting it. Don't forget Streamlabs. I don't forget Streamlabs. Oh, because I don't announce those on stream? Right. I need to figure out how to do that. I need to bring back the Streamlabs bot that I used to have that announced it on screen. I need to bring that back because there's no way for me to see it in real time right now. But let's take a look at this article from CNBC. And I appreciate everyone who donates in Streamlabs. I should probably just, note to self to add it back into the stream so that it'll at least pop up on screen so people can get recognition. But anyways, let's cover this article real fast. Biden COVID vaccine mandate for federal workers blocked by second federal court. A federal appellate court has declined for now to allow the Biden administration to require it for federal employees. The Fifth Circuit Court of Appeals, not surprisingly, ruled 2-1 on Wednesday to maintain a block on the mandate that a Texas federal judge had issued on January 21st. Federal court has decided for now to allow Biden, has declined for now to allow them to require the vaccine. The Fifth Circuit Court of Appeals in New Orleans ruled 2-1 on Wednesday to maintain a current block on the mandate the Texas judge had issued. The administration asked New Orleans court for an injunction allowing the federal work mandate to put forward pending appeal. Judge Jeffrey Brown, who was appointed for the district court for Southern District of Texas, issued an injunction against the requirement last month saying Biden administration exceeded its authority. The Fifth Circuit panel didn't address the merits of the case. It was a brief order from the judges putting off a decision on whether to lift the injunction pending further proceedings and ordering filings. And then so did they make a decision or did they not make a decision? So it looks like they didn't make a decision. They just want more briefing. But at least they didn't decide immediately the other way around. So that's pretty interesting. So yeah. So all that good stuff. Okay. So anything else before I end the stream? It doesn't look like it. It doesn't look like it. Okay. Well, then that will be the end of the stream. So thank you everyone for being part of this stream as always. I hope you enjoyed this. I hope you got some good legal education about what OSHA is trying to do and what differences it makes versus what happened before, and some problems OSHA has with this mandate and why I don't really think it's going to go much of anywhere. And as Stephanie pointed out in chat, some states are requiring this, like California, for example, in their OSHA. So California is requiring it as a matter of their state law. But, as I pointed out before, what California can do as a matter of its state law and what federal authorities can do as a matter of its law are, of course, different propositions. So I'm sure they'll try, but I don't see how they're going to be able to issue this mandate in a way that will stick. But I suppose we'll find out as they continue to go through the regulatory process. If you've enjoyed this stream, please remember to do all the YouTube things. Like, comment, subscribe. If you're not an Uncivilian, for 99 cents, you too can become an Uncivilian. It's true. You get a cool little icon by your name, and as you saw during the stream, you get your name scrolling to show that your support. So it's a little bit of benefit, right? You get your name on screen to show that you are a supporter. How fun and exciting to be an Uncivilian. So I would appreciate your continued support. As always, I hope all is well, my friends. Until later, cheers and goodbye.